Good evening and welcome to Reach Lawyer webinar on Trafficking Bill, Empowering NIA and Disempowering People.
ये गलियों के आवारा बेकार कुत्ते आए गलियों के आवारा बेकार कुत्ते काले पीले नीले सब रंगदार कुत्ते बख्शा गया जिनको जोके गदाई जमाने की फटकार सरमाया इनका जहां भर की दुत्कार इनकी कमाई बस ट्रक ट्रेन और ट्रामों में बेशुमार कुत्ते आए गलियों के आवारा बेकार कुत्ते न आराम सबको न राहत सवेरे लाजत में घर नालियों में बसेरे जो बिगड़े तो एक दूसरे से लड़ा दो जरा एक रोटी का टुकड़ा दिखा दो फुटपाथों पे खर्च होते ये तमाम कुत्ते आए गलियों के आवारा बेकार कुत्ते ये हर एक की ठोकरे खाने वाले ये फाकों से उकता के मर जाने वाले ये मजलूम मखलूक कर सर उठाए तो इंसान सब सरकशी भूल जाए ना खोटे ना जंजीरें बेलगाम कुत्ते आए गलियों के आवारा बेकार कुत्ते ये चाहे तो दुनिया को अपना बना ले ये आकाओं की हड्डियां तक चबा ले कोई इनको एहसास जिल्लत दिला दे कोई इनकी सोई हुई धुन हिला दे 10, 20, 40, 100 करोड़ कुत्ते 10, 20, 40 नहीं भाई 100 करोड़ 10, 20, 40 नहीं भाई 10, 20, 40 नहीं भाई 100 करोड़ कुत्ते 10, 20, 40 नहीं भाई 100 करोड़ कुत्ते
Very good evening. Welcome to Reach Lawyer. Reach Lawyer webinar today is on the Trafficking Bill 2021. This bill has been one of contention. It has been stated by the government that it's absolutely essential and needed at this time. A number of activists, lawyers, doctors, scholars, many of them who are working on this subject are questioning, raising issues, and that's really disturbing. And there have been a number of seminars, webinars, articles that have been published on this subject. Why these people are questioning this trafficking bill? Trafficking bill is something which is needed, says the government. Well, as one who has been a prosecutor, one who has been a defense counsel for more than 3 decades in the profession, and one who has been working with the sex workers and transgender communities for more than 2 decades, I can squarely say that this law of immoral trafficking has been used more particularly to the most vulnerable among the communities. That has been its big challenge to us. Now, given that kind of a situation, what exactly is in store in this new trafficking bill? What exactly is this that makes the people so angry, some of people so angry about this particular law? One of the first things is that this particular law talks in terms of introducing National Investigating Agency for the purpose of investigating the cases. There is a serious question that this affects the very construct, the federal structure. We know what exactly National Investigating Agency Act. There have been series of debates and questions and articles relating to this and in respect of the way of functioning, the way it has been used, the way it has been investigating the issues. In fact, large number of cases in Unlawful Acts Prevention Act has been board of contention. In fact, recently we had number of retired Supreme Court judges who are very angry with the way the law has been used as against civilians and trying to muzzle its power, trying to make it so difficult for people to even express their dissent as against the state is concerned. That's one of the major challenges the government is facing. At that particular point of time, we have this new trafficking bill. This bill introduces aspects which are really of serious concern for many. There is issue of privacy, there is issue of incarceration, there is issue of the construct of counseling that's being, doctors are scared, so many aspects. In fact, this is throwing up million questions. Today in our webinar, we have one of the finest experts come and explain and raise these issues, why they're concerned about the new trafficking bill. Today with us is Lakshmi Murthy, a journalist of decades of experience, an experience which is amazing, and she is co-founder of Free Speech Collective. She has so many things to go to her credit, but this is something which is so crucial at this point of time. She has been vocal about the rights of the people. She is vocal relating to the freedom of expression, and she heads institution across Asia, and she's also a contributing editor to the magazine, which is talks in terms of the political situation in South Asia. And she has been with us today in this respect of free speech and the construct of the trafficking bill, how it's going to affect that. She's going to describe, explain regarding the same. The second guest panelist whom we have today is Bishakha Datta. Bishakha Datta is one of the finest writer, filmmaker, activist, and a thinker in respect of gender-related issues are concerned. The kind of work she has done over the decades speaks volumes by itself. And she is here today talking in terms of the aspects relating to the pornography, the digital content, and how it's going, this particular law is going to affect on those issues and rights, how the people are going to be impacted with this new law. She's going to speak on that. Today we have one of the finest lawyers, Arti Pai, who is also executive director of Sangran Sanstha, which is working on the rights of the women, more particularly the sex workers in India. And she's also an advisor to National Network of Sex Workers. She is going to be here today, explain the overview. She has been an amazing lawyer who knows this particular law through and how it has been impacting sex workers. She's been going to present that today on the aspects relating to overview of this particular law and also relating to how it impacts the communities and why communities are concerned about the same. And today we have a representative from the community itself, the Aisha Rai, who is the coordinator of the National Network of Sex Workers and a very vocal voice in respect of protection of rights of the sex workers in India is concerned. She has been forefront of many struggles relating to the impact which the immoral trafficking laws have done as against the women are concerned, more particularly women and transgender sex workers. She has been very vocal on that particular. She is joining us today to explain the aspects, how it's going to impact on the sex workers and how the sex workers are looking at this particular trafficking bill. She's going to present us the same. We have today also Pompey Banerjee. Pompey Banerjee works on trafficking issues. She works for Sanjog, an organization, and she's amazing. She has done great amount of work on these issues, and she's a psychologist, and she is an advisor, and she has been for years working on these issues. She's today joining us, talking in terms of what it means in respect of trafficking, relating to the rights of women, more particularly the vulnerable one, related to the aspect of the shelter and other things. She's going to present us today. She is one of the finest exponent on this particular subject is concerned. Today, with these speakers, we are going to have a discussion relating to a subject which is of profound importance at this point of time. People are asking serious questions. Why this law is being brought into force without there being a serious debate on this particular law? What exactly, how the law should be? When we say that the Constitution of India has the space very clearly mandated that the trafficking should be curbed, India is a country which has serious issues regarding trafficking is concerned, whether it is bonded labor, whether it is child labor, whether it is pornography issues, whether it is sex worker rights are concerned, sex workers, trafficking and sex work is concerned. Many of these aspects which have been of serious concerns. The present law tries to encompass all of them into one law. That's something which is at one look, it looks ambitious. At the same time, it has serious concerns for these issues. Today, with this law, we are here to discuss and see what exactly is that makes people so concerned about the law of trafficking, the law of the new trafficking bill that is being presented to us. The first and foremost challenge, which is talking in terms of empowering NIA and disempowering people. Now, that's the profound statement. What exactly is that? I think today, to begin with, we'll have first panelist who is going to present on this particular aspect is Aarti Pai. I request Aarti Pai to come and start making a presentation. Hello, Aarti.
Good evening, BT. May I have sharing screen, please? Thank you. May I have screen share, please?
Yes, ma'am, you're the host.
So thank you very much, BT. And at the outset, I really would like to thank Reach Lawyer because you're setting up an incredibly crucial panel discussion today. The draft Trafficking in Persons Bill was put on the Ministry of Women and Child's website on the 30th of June, and comments were invited till the 15th of July 2021. It was a remarkable turnaround time within which this very bill is now slated for introduction in the current Parliament session, which began last week. So it tells us a little bit about the speed or the haste with which things are moving ahead. I will discuss some of the concerns that have been flagged by a coalition of civil society members on this bill. I still have not been enabled and vote. Thank you so much. I have started now. All right. So the biggest challenge, as has already been pointed out by BT, and one of the most overarching concerns that most of us are having with this bill is the introduction of the National Investigation Agency as the primary agency for investigation and prosecution, and what it means in terms of disturbing the entire federal structure that we have, in terms of diluting and whittling down state powers. There are approximately about 15 major issues that have been flagged with reference to the current draft trafficking bill. I will attempt to address as many as I can within the allotted time. Now, I was asked to give a brief understanding of what has shifted with reference to this trafficking bill. So I'll try to put it into very, very precise terms. As many of us understand, the offense of trafficking rests on three critical pillars: the act, the means, and the purpose. So what I have listed here is a comparative analysis between Trafficking Bill 2021 draft Section 370 of the Indian Penal Code, which is there in our statute books, and the Palermo Protocol, Article 2, which came about and is the international standard, the minimum standards. So if you look at the three elements, the act which is there in blue, the means which is being listed in front of you in green, and the purpose has to be exploitation. So when we look at a comparative analysis, we find that the trafficking bill is pretty much the same in terms of the three elements that go to define trafficking. What happens is actually the next round when you enter the arena of how it understands exploitation, and that's where the current trafficking bill is attempting to take off. And I have tried to flag some very basic things in the section 23 of the draft trafficking bill, which is on your left, where you have the introduction of terminology such as pornography. That's number one. The second thing that's really attempting to take the current proposed definition of the trafficking bill into another realm is the fact that now the victim need not be physically moved or transported to constitute the offense of trafficking. So you really have one more layer which is now being removed to understand, to make it immaterial in the determination of this offense. And these are all going to have tremendous impact. Flagging what I said there as exploitation, if we understand what are the multiple definitions being brought in with the current bill, in addition to what was just put up on your page as section 23's definition, there's an additional expression which has entered under section 27, and this is a little troubling for us, where it says that exploitation includes causing of harm to or taking of benefit, gain from a victim without due or appropriate consideration. Now, the question begs itself, who decides what is due or what is appropriate consideration or compensation? And it has huge portent for the way this trafficking bill is moving forward. It also brings in a definition of sexual exploitation, which is in addition to the section explanation, which is there in the trafficking definition under section 23. So it says obtaining of financial or other benefits to the involvement of another person in prostitution, sexual servitude, or other kinds of sexual services, including pornographic acts. So in addition to the layer that you have in section 23, you're now finding a new definition also of sexual exploitation. I'll pause here for, because this is literally the least that I can explain as the basic framework and the shifts that are happening. What is going to be the impact when you begin reading some of the new definitions that are being brought in? Up front, we are looking at the impact that this bill is having in criminalizing livelihoods, not just people, livelihoods. So up front, it is the female trans sex workers, those sex workers working in brothel spaces, because anybody who supports a sex worker to be able to do her or their sex work safely is now going to be criminalized under the provisions that I have put below, which means any person who goes as a customer, an employer, customer, pimp, broker, section 30 explanation 2 is very clear. Customer, employer, pimp, or by whatever name. So clients of sex workers are going to be criminalized. And we need to understand that this is really going to hit at the very livelihood of sex workers. So instead of actually empowering them to negotiate for better working conditions, better wages, to help them to come together to put an end to exploitative practices, we are actually moving into a space where we are criminalizing the client, we are criminalizing the sex workers, supporters, called the agents. We call them third party. Another problematic assumption here is criminalizing of the very workspaces and eviction. Now, one of the provisions of the current draft states that if the premises, there are episodes of trafficking or exploitation of victims, the premises may, an order may be passed evicting occupiers. Now, often many of us know these brothel spaces are actually occupied by families of sex workers. And we have examples in Maharashtra where after the eviction and locking of these brothel spaces, children were thrown out onto the roads and you had women being moved to rehabilitation homes. So that's one primary concern. There are tremendous implications of this proposed bill for the industry and for labor rights. I've already gone through the new definition of exploitation. So what's happening here is exploitation that is understood to be trafficking is now getting linked with not getting due or appropriate consideration. So that's exploitation, and then the exploiter is supposed to be a trafficker. And the giving of money or remuneration is going to be absolutely immaterial when you are determining an offense of whether or not a person is a victim of exploitation. The implication for this in terms of people who are working with supply chains is the clause under section 30 explanation 3, where persons engaging with supply chains where there is a possibility that they may have been a direct or an indirect exploitation of such victims. And what is exploitation? It could also be not getting due or appropriate consideration. So that is a space of exploitation, and the person engaging with such a supply chain is also deemed to have committed an offense. Now, what we are now witnessing is an entire shift from a paradigm of rights. It's a shift from a paradigm of collective bargaining to this criminal framework where you're actually a victim in need of rescue, and the strategy is rehabilitation rather than wage bargaining and negotiation for better working spaces, better wages. There is a presumption of offense rather than a presumption of innocence. And this is very, very critical for many of us who have now also been seeing laws emerging around this notion of presumption of innocence and versus presumption of offense. So in this case, section 46 is laying down that offenses where the victim or the survivor is a child, a person of limited mental ability or physical disability, or a woman, then the entire presumption is that the person has committed the offense, unless the contrary is proved. Now, we know that in criminal jurisprudence, presumption of innocence and burden of proof on prosecution is the heart of criminal jurisprudence. When you remove this presumption, you critically are impacting that individual's fundamental right to life and liberty. Now, this would also translate into episodes of incarceration when one is charged with the offense in violation to their rights of liberty and life. Most critically, we also know that in criminal law, offenses need to be directly and precisely defined, and the ingredients which then constitute that offense must be established in court. However, section 46 is absolutely turning this on its head, and when the court, it states that the court may presume the commission of the offense unless the contrary is proved. And investigative agencies have the powers to question, examine witnesses, they have the powers of search, seizure, collection of evidence. But these powers are not there with the person who is the accused. Materials and the individual does not have the power to question witnesses, to search a place, seize material, therefore making the task of this proving to the contrary immensely difficult and maybe even impossible. There's another very, very disturbing entry which is made in its entry into the trafficking bill, and that is the death penalty. Many civil rights activists, NGOs working on the ground have consistently called for removing death penalty outside the ambit of these sort of punishments. And there's a reason for this. There's no evidence to show that death penalty is an effective deterrent for an offense. It is not. There has been no evidence placed. Most importantly, one of the things that's been happening after Nirbhaya is the call by NGOs that when you put death penalty on the table, you actually threaten the very life and security of the people that you're trying to prevent harm coming to. Then there is a problem of drawn out legal processes, the trauma, where there's no adequate and appropriate support. And you are actually imposing that additional layer on them. The Supreme Court has consistently pointed out that imposition of death penalty has been, there's arbitrary decision-making, it is subjective. Post confessions are there, and the impact of the death penalty is often on economically vulnerable backgrounds, backward classes, and religious minorities. Despite this, death penalty has made its entry under Section 26 of the current trafficking bill. And the last suggestion that I'd like to make is the problem associated with prolonged incarceration. There are two provisions that are attempting to limit the right to freedom till an individual is convicted of an offense. One is there's a complete denial of anticipatory bail to individuals who are accused of offenses where the imprisonment is above 2 years. Second is under 49, Section 49, the conditions that are being now imposed even on regular bail. So there are wordings like there should be reasonable grounds for believing that the accused is not guilty of such offense before granting bail. And that amounts to a virtual denial of bail and the prolonged incarceration, curtailment of liberty. In conclusion, all I'd like to say is there are many, many more problems with this bill, and I hope that in the discussion session we can add on to many more of these layers. Thank you very, very much.
Thanks, Aarti. It's a pleasure. These are the issues that really challenge the whole law. In fact, it's opening up a new scheme of things that is affecting the very structure of the fundamentals that have been guaranteed to citizens. So therefore, this law need to look critically from that particular aspect. Thank you. We'll come back to you again when we have the next session. I request Aisha Rai to join us now.
Hi, नमस्ते सबको. आयशा नेशनल नेटवर्क ऑफ सेक्स वर्कर्स से. जैसे कि धन्यवाद करना चाहूंगी कि इस मंच को आप लोगों ने मुझे मौका दिया कम्युनिटी को रिप्रेजेंट करने के लिए. जैसे कि ट्रैफिकिंग बिल जो आया हुआ है इस परिस्थिति में और इतने ज़्यादा उसमें ऑफिसर बहुत सारे उसमें प्रॉब्लम्स है कम्युनिटी को लेके या नए नए कायदे लाए हैं और उसमें इतना बड़े बड़े पनिशमेंट डाले हुए हैं जैसे कि NIA का जिक्र किया है बीटी सर ने, आरती जी ने, और डेथ पेनल्टी का भी बात हुआ है. और हालांकि ये भी दिखाई दे रहा है कि हमारा जो पूरा वर्क प्लेस है उसी को हमारी जो हमारे सेक्स वर्क में जो भी हमारे पार्टीज थर्ड पार्टीज रहते हैं जैसे कि क्लाइंट्स है, ब्रॉथल ऑनर्स है, इन सभी को ही बहुत ही खतरनाक प्रकार से पनिशमेंट दिया जा रहा है. लेकिन सेक्स वर्कर्स हम हमेशा यही बोलते आ रहे हैं कि सेक्स वर्क को कंप्लीट ना करें ट्रैफिकिंग के साथ में, क्योंकि सेक्स वर्कर्स लोग ये समझते हैं कि धंधे में हमारे सेक्स वर्क में आना भी उनकी अपनी कंसेंट रहनी चाहिए, एडल्ट कंसेंट रहनी चाहिए, और एग्जिट करने के लिए भी अपना कंसेंट रहना चाहिए. और NNSW जो है इसी को लेके ही अभी तक हम अपनी कम्युनिटीज के साथ में काम करते रहे हैं. और साथ ही ये भी हुआ है कि हम अपने सेक्स वर्क को एक काम के रूप में मान्यता करते हैं. हम सेक्सुअल सर्विस देते हैं क्लाइंट्स को और उसका प्रोविजन रहता है गुड्स को लेके, एक्सचेंज ऑफ गुड्स या फिर अपना सामान को लेके. लेकिन हमें हमेशा ही सेक्स वर्कर्स को या तो इमोरल ट्रैफिक प्रिवेंशन एक्ट जो कि 1956 का जो है उसी को लेके ही चलेंगे, तो उसमें भी हमें ये दिखाया गया है कि सेक्स वर्क को जो है हमेशा ही कॉन्फ्लिक्ट करके ही सेक्स वर्कर को एज अ क्रिमिनल दिखाया गया है, एज अ विक्टिम में पुश किया गया है. और इसके वजह से जो कि जब आप लोग कन्फ्लिक्ट करते हैं सेक्स वर्क को ट्रैफिकिंग के साथ में, द कम्युनिटीज के ऊपर में जो फीमेल या ट्रांस पर्सन सेक्स वर्कर्स जो भी हैं, उनको इस तरह से पुश हो जाते हैं हम लोग कि हमें 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 एकदम अंडरग्राउंड हो जाना पड़ता है हर चीज से। हम सेक्स वर्क अर्न नहीं कर पाएंगे क्योंकि मानसिक स्थिति ठीक नहीं रहेगी। और दूसरी चीज ये है कि हम HIV सर्विसेज या हेल्थ सर्विसेज से वंचित हो जाते हैं, या इतना ज्यादा डर रहता है कि हम हाई रिस्क लेवल में चल जाता है। जैसे कि उदाहरण में मैं अपनी बात करना चाहती हूँ, मैं खुद एक माइग्रेंट सेक्स वर्कर हूँ, और जब जब ये ट्रैफिकिंग का बात आता है तो मुझे पहले ही डर लगता है, क्योंकि कहीं ना कहीं ऐसा लगता है कि इस बिल के अंतर्गत में भी ये भी दिखाया गया है कि इंटरस्टेट के अंदर में भी कोई भी एक जगह से दूसरी जगह को भी जा नहीं सकते, इस चीज का भी पाबंदी किया है। तो इस बिल आने के बाद में मेरी जो है एक फ्रीडम ऑफ मूवमेंट को भी ललकारा जा रहा है, और मुझे तो पहले ही एज अ ट्रैफिकिंग विक्टिम बोल के माना जाएगा, फिर मुझे रेस्क्यू किया जाएगा, और फिर क्या होने वाला है, मुझे रेस्क्यू किया जाएगा, फिर मेरे परिवार को मेरे से वंचित हो जाएंगे, और उनका फिर प्रेशर रहेगा मुझे किस तरह से देखना है, फिर इसी से ही मुझे इतने सारे पैसे मैं कहाँ से लेके आऊंगी मेरे बेल करवाने या फिर मेरे परिवार को देखने। ये सारा चीज जो है मुझे और भी ज्यादा एक्सप्लॉयटेशन में पुश किया जाता है। इस प्रकार से मुझे अपने आप को दर्शाया, इस तरह से दिखाई दे रहा है अपने आप को लेके। और जो है जो भी कानून वगैरह बनाए गए हैं इस बिल के अंतर्गत में, सेक्स वर्कर्स का पहले से ही मतलब 370 हो या 1957 370 IPC और 1956 को ITPA के जो भी कायदे कानून है, उन दोनों ने तो अभी तक की सेक्स वर्कर्स को, ब्रॉथल सेक्स वर्कर्स को या स्ट्रीट लॉज सेक्स वर्कर्स को हमेशा ही एज उसको विक्टिमाइज किया है। लेकिन हम सेक्स वर्कर्स हमेशा ये बोलते आ रहे हैं कि कंसेंट जो है सेक्स वर्कर्स का, एडल्ट का जो है विषय, उसको मान्यता दिया जाए, क्योंकि मैजिस्ट्रेट ने भी काफी ये केसेस किया है। जब उसको रेस्क्यू किया जाता है, मैजिस्ट्रेट के सामने जब लेके जाते हैं, तो मैजिस्ट्रेट भी बोलते हैं कि नहीं, इसको रेस्क्यू होम में भेज दो, ये ट्रैफिक औरत है, उसके कंसेंट को नहीं मान्यता देते हैं, और उनको ये बोला जाता है कि उनकी बिहेवियर को चेंज करना है। इस तरह से रेस्क्यू होम भी भेजा जाता है हमें। और फिर बाद में जब बेल अगर हो गया तो सिर्फ मतलब मेरी उम्र अभी 35 साल है और मेरे भाई 18 साल के भाई के हाथ में, फैमिली के हाथ में मुझे भेजा गया है। इस तरह का कायदा कानून है। तो मैं एक एडल्ट हूँ और मेरी एडल्ट की सहमति को बिल्कुल भी मान्यता नहीं करते हैं, तो मेरी मानव अधिकार कहाँ जाती है? यहाँ से पूरी छीन के ये लोग अपने तरह से चलने के लिए इस तरह का प्रकार बनाया गया है। NIA वगैरह इतने बड़े बड़े सिस्टम को डाल के, और प्लस इतना बड़ा डेथ पेनल्टी को भी ला के साथ में, और इस प्रकार का जो लाइवलीहुड जो हमारा परिस्थिति है, ये और भी ज्यादा हमारे परिवार को या मेरे फैमिली को या मेरे को, हमें इतना ज्यादा हमें एक पुश किया, इतना ज्यादा से नीचे हमको लेके जाता है कि वहां पे हमारी आवाज रखने को भी हमें जगह नहीं मिलती। इस तरह का ये कानून सब बनाया जा रहा है। और साथ ही में एक ये भी बात बोलना चाहूंगी कि अभी के परिस्थिति में कम्युनिटीज को लेके, अभी इतना ज्यादा कम्युनिटी कोविड को लेके झेल रहा है। अभी 2-3 साल हो गए हैं, लाइवलीहुड पूरा चला गया है सेक्स वर्कर्स को। दूसरी चीज ये है कि अभी फ्लड्स भी आ रहे हैं काफी एरियाज में, इतने लोग फ्रस्ट्रेटेड है। एंड ये तीसरा चीज आ गया अभी ट्रैफिकिंग में, सारे कम्युनिटीज इतने ज्यादा परेशान है, इतने ज्यादा मेंटली वो लोग प्रेशर में है कि कब क्या होगा, कब क्या मिल जाएगा। मतलब सेक्स वर्क एक काम को ध्यान भी रखने का उनको मानसिक स्थिति नहीं आ रही है। इतना मतलब कम्युनिटीज की ऐसी परिस्थिति आ रही है कि अब कोविड रहते रहते भी झेल रहे हैं, चल रहे हैं, थोड़ा मोड़ा घर परिवार चला रहे हैं, लेकिन साथ ही में अब ये फ्लड भी आ रहा है, उसको भी मैनेज किया जा रहा है। लेकिन ये बिल से जो पूरा खत्म करने वाला है, ये बिल लाके जो इतना ज्यादा प्रेशर कर चुके हैं, और ऐसी परिस्थिति में जो कि पहले से ही दो चल रही है, तो हमें ऐसा लग रहा है कि इस बिल लाके हमें और भी ज्यादा हमें हमारी परिस्थिति को और भी ज्यादा हमें कम्युनिटीज को पुश किया जा रहा है और भी एक्सप्लॉयटेशन, क्योंकि हमें खुद भेजा जा रहा है। क्योंकि अभी के परिस्थिति में अगर कुछ भी हो गया मेरे परिवार को या फिर मेरी कम्युनिटीज के उनके परिवार को, अभी की परिस्थिति में नहीं है कि कुछ भी हम दो चार पैसा हम ले सके। और सेक्स वर्कर्स की कम्युनिटीज के अंतर्गत में इतने बड़े बड़े हाई लेवल के लिंक नहीं है। हमें अगर पैसा भी कहीं से मिलता है तो 20% 30% इंटरेस्ट से हमको लेना पड़ता है। ऐसी परिस्थिति, और इस कोविड और ये फ्लड के टाइम पे कौन हमें देने वाला है? तो ब्याज के ब्याज ऊपर चलते जा रहेगा और ये हमें प्रेशराइज किया जा रहा है।
Thank you.
थैंक यू।
We'll come back. We'll come back to you again once the presentations are over. I now welcome Pompey Banerjee to make her presentation as a panelist. Ms. Pompey.
Thank you so much. I would like to keep my presentation focused on the model of rehabilitation that is being proposed in this draft anti-human trafficking bill. There are a few things that I liked about the bill. The fact that it makes a concerted effort to shift the focus of this anti-human trafficking bill from the outcome to the process of trafficking, which was a huge problem in ITPA, that in the name of focusing on human trafficking, it was squarely focusing on sex work, and it was conflating trafficking with sex work. This bill's way of defining trafficking is moving away from that focus, which I appreciate. Having said that, I do believe there are areas that this bill requires to be to re-look at, especially around the rehabilitation model. The current rehabilitation model that is practiced largely is a very linear one, where a person is rescued and then put into an institutional shelter home for rehabilitation. Thereafter, they are reunified with their home community, with their family, and eventually followed up with an individual case management approach. In this bill, it does not really shift away from that linear process. While the bill gives a definition of rehabilitation, the definition is kept very open to interpretation. It talks about restoration of a survivor's physical, mental, and social well-being. However, what it would mean, what would that restoration look like, is very unclear. The idea of restoration that this bill proposes is a questionable one, because this particular approach to restoration, it essentially assumes that a person who has been trafficked was in an optimal condition of well-being prior to the trafficking. However, if you look at the demographic profiles of trafficking survivors, it shows very clearly that victims of trafficking are often from marginalized communities that face different kinds of violence and exclusion, which exacerbates their vulnerability to trafficking. This notion of restoring also neglects the impact of trafficking and exploitation on a survivor's identity and sense of self. A survivor of violence and trafficking is subject to different kinds of crimes, including kidnapping, abduction, confinement, physical torture, blackmail, threats, grooming. And the trauma that the survivors report, therefore, are not only the experiences that occur only during the exploitation by traffickers, but also by the composite effect of deprivation and causal factors that lead to the entrapment of victims. So, for example, a survivor who has been trafficked from Chhattisgarh to another state, when they were contracted that you will go and work in a construction site, and they were given a lump sum amount as advance. However, when this person actually goes to the work site, they realize that the advance that was given to them is now going to be deducted from their payment, and they are going to be detained in a brick kiln against their wishes. They cannot come back to their state even if they want to or they need to. Now, in this entire situation, after they manage to exit, or even when this person is finally rescued from this trafficked condition, the trauma that they report is not only about what happened when they were kept detained forcefully in that brick kiln, made to work beyond hours, were not paid or were not fed well, where they were coerced or blackmailed. The trauma that they are going to report will come from whatever they have experienced during that exploitation, they have experienced prior to the exploitation and trafficking, and their experiences with the criminal justice system and the social welfare organizations after they have been rescued. Now, if we look at rehabilitation from that lens, this particular notion of restoring cannot therefore be erased from their minds. It cannot be undone. This notion of rehabilitation, therefore, needs to look at what would rehabilitation at the minimum achieve. The aim of rehabilitation, therefore, cannot be only to restore. It needs to focus on empowering the survivors to reclaim their agency, to build their resilience, and to claim their space in their community of choice as citizens of this country. The process of rehabilitation, therefore, cannot be limited to the shelter home-based model that we have been following so far. And all of us know by now, there has been wide media reportage how shelter home-based rehabilitation does not work. It offers, shelter homes are great for offering short-term protection and support services. But for longer-term rehabilitation, shelter homes neither have the kind of services that survivors often require, especially for recovery from trauma, both in terms of physical trauma and mental health trauma. Neither can they provide the kind of individualized support services that a survivor may require. For that, the rehabilitation must be community-based. The Trafficking in Persons Bill, therefore, must redefine the rehabilitation for victims of human trafficking. It must also define what would reintegration and assimilation look like. Because without those critical pieces, the understanding of rehabilitation will not be completed, and when it will be finally implemented, the scope of rehabilitation will once again remain very, very limited. So when I'm talking about rehabilitation, what am I really talking about in terms of community-based rehabilitation? We are talking about a person who has returned to a community, and it does not need to be their home community. We know by experience in across multiple states that there are certain concerns when it comes to a survivor seeking assimilation and reintegration in their home community. Oftentimes, families have concerns around acceptance of the person back into the family, or if the entire family, we know in the context of labor trafficking, often it is the entire family who gets trafficked. Therefore, what would it mean for this family to come back to their home state and seek rehabilitation support is unclear. What kind of support can they expect from the government? We are talking about support system from the panchayat, support system from the BDO's office, support system in terms of social work, support system in terms of legal aid to claim their entitlements, not only to access victim compensation and reparation support, but also to seek necessary legal processes if their rehabilitation has not been taken care of. And in talking about rehabilitation, I do believe that victim compensation must be considered to be a part of a person's rehabilitation, which once again means that a person who is going through rehabilitation must have access to quality and affordable legal aid. They must have access to need-based livelihood and financial inclusion support. Current research clearly shows that only skill development that happens in the shelter homes don't lead to livelihoods and income security. And when we are talking about rehabilitation in the context of this new anti-human trafficking bill, we must keep in mind that we are talking about trafficked survivors who have not been trafficked only for sexual exploitation. They may have been trafficked for multiple different kinds of exploitation, including labor. So if we are talking about, if we take, for example, where boys are trafficked from Bihar to Rajasthan to work in factories for making fireworks, their rehabilitation will need to be, the plan need to be made keeping in mind their context and their needs. Therefore, only a skilling program offered through a shelter home, one size fits all, will not be applicable. It will not be effective. Under the current rehabilitation definition that the bill provides, it will merely become a checklist of services to be provided. We will not be able to assess whether a person is really receiving the rights that they are supposed to receive. Therefore, yes, we do need to look at redefinition of rehabilitation, and we need to look at incorporation of community-based rehabilitation within that definition of rehabilitation. Last but not the least, the rehabilitation cannot be restricted by any conditions. A person should not need to be quote unquote rescued to have access to rehabilitation support and victim compensation. The support for rehabilitation, victim compensation must be made available to that person in the community of their choosing, wherever they choose to reside. Now, the bill talks about the creation of a district anti-human trafficking committee, which is supposed to ensure that all survivors receive rehabilitation support services. While it talks about who will be the members of this committee, one of the biggest gaps is that there is no mention of inclusion of survivors themselves, either being part of the committee or being part of the stakeholders who will hold these committees accountable. And this is where I believe the accountability measures for these committees need to be further strengthened. The transparency of their meetings, of their actions, must be ensured through periodic reports made available to the public. And survivors of human trafficking, of various kinds of trafficking, who are receiving the support services under this bill, they must be taken into the framework of active participants and in monitoring and auditing of the law. And the law's implementation, therefore, must take into consideration their engagement and feedback. If they are saying something is not working, the government must engage with the survivors in order to seek solutions. Now, with this, I would like to take a pause here and listen to the other panelists.
Sure. Thank you, Bumpy. I now request Bishakha Dutta to come and make her presentation. Bishakha?
Thanks so much. And thank you, Reach Lawyer, for inviting me to speak at this critical panel. So I have been working for the last 5 years at the intersection of gender, sexuality, and digital technologies. And from that perspective, the clause that actually struck me the most was the introduction of pornography into this version of the trafficking bill. And the definition of sexual exploitation has been expanded to include pornographic acts or production of any pornographic material. So what I would like to say actually is that, this is probably a clause that has been introduced, pornography, because of the prevalence of digital technologies. As we saw in 2020 and as is continuing now, we have gone from being a physical society with a sort of digital add-on to now largely becoming what I call a phygital society, right? Where we have both digital and physical. And while pornography itself has, from its inception, been essentially the use of media for sexual purposes, it has in the past taken forms of media like books, films, graphics, audio, video, etc., depending on the technologies that prevailed in the society at any given time. And of course, in this current context, where mobile phones and digital technologies are the most used and fastest growing technologies in India and across the world, actually, with almost 450 million mobile phones being used last year. Today, of course, when we think of pornography, the technology we think of is the technology for which pornography is primarily produced and distributed. That's for digital devices and online spaces, right? So anything from the simple phone to WhatsApp to direct messages on social media to dating and other platforms. That's really where pornography today lives. Now, if we think about this, first I'd like us to actually think about it, particularly in the COVID-19 pandemic context. We saw last year many sex workers around the country losing their means of livelihood and struggling to earn a living. We saw how last year many of them were constrained, and I use the word constrained very intentionally, to use digital technologies, including mobile phones, to somehow try and eke out a living by communicating with their clients through videos and images, right? So the way this would work, for example, is, say a sex worker might have a mobile phone, might get in touch with numerous clients separately. And the exchange of sexual services through digital devices can happen in many ways. It can happen live, right, with the sex worker showing live video to the client. It can happen recorded by sending a video. It can happen through photographs, etc. The problem with this particular trafficking bill is that it defines all these not as sexual acts, but as pornographic acts. And it automatically equates pornographic acts or production of any porn material with sexual exploitation. But if you look at it through the eyes of sex workers, this is actually, the mobile phone and the app that's being used is not inherently sexually exploitative spaces or these acts of production. I would actually say that these apps and phones are now like their digital workspaces. When we think about the street, when we think about the brothel, when we think about, hotels, etc., as physical workspaces, frankly, the mobile phone and the app is the digital equivalent, the digital workspace. But when these are deemed inherently exploitative production in these spaces, then to my mind, it basically robs sex workers of their digital workspaces and their essential working tools, which are videos and photos. And so deeming these sexual exploitation basically deprives sex workers of their livelihood opportunities. There are other ways to think about pornography through the lens of sex workers and how to actually create safe working conditions when material that is, for sexual purposes, video or audio or photographic is being used. And I think the ways to do this are actually to understand the challenges and harms of producing sexual material directly from workers in these spaces and industries, and then to focus very much on removing the exploitation within the creation, distribution, and use of sexual material, and trying to establish safe working practices and conditions in the creation and distribution of sexual material by adults. And I will close with just one or two examples. When we last year talked to sex workers about their experiences using mobile phones, right? They talked about the harms that they faced. And one of the harms that they faced, or potential harms, excuse me, was really the fear that their recording would be taken without their consent and circulated and shared. Or there were instances where sex workers said they hadn't been paid, right? So I think, again, we need to reframe the concept of what is sexual, what is pornographic or erotic without necessarily being harmful, and separate it from what is harmful pornography, etc., as we look at sex workers continuing to use digital spaces more and more to earn their livelihood. On that note, I'll leave it here. Thanks very much.
Thank you very much, Vishaka. It makes sense. I now request Lakshmi Murthy to come and make her presentation. It makes sense.
Good evening. Hello, everyone. And thank you so much, Venkatesh and Reach Lawyer, for this opportunity. I think it's really interesting and important to widen the debate to non-lawyers and also people specifically working on trafficking. So I see this as a very important initiative and panel. I'll be speaking from the media perspective. And in the past few days, a lot of people within the media also have said, what is it about this new bill that affects the media? I mean, the media, of course, has to cover the issue and discuss it and debate it and critique it. But does it really, affect the media at all? And the short answer is yes, it does. In ways in which may not be so apparent right now. But what is happening with this law, like with a lot of laws which have been passed in the recent few months or years, is that there is an increasing tendency to control, to be intrusive, and to criminalize. And this law follows all these 3 points. So even for the media, it is not only about controlling traffickers or alleged victims or survivors of trafficking, but it is also controlling the media. So it's, nobody's case that the media does not need regulation, or that the digital space should be a completely unregulated space, because we see also that the digital space mirrors the physical space in terms of perpetuating marginalization or inequality. So it's not a wonderful, equal opportunity space out there. So there is certainly a case for regulation. But we as the media have always pushed for self-regulation by bodies who are directly affected and by bodies who are part of the larger media landscape. So media bodies must be part of self-regulation. What this law instead is doing is it is controlling and criminalizing a large swath of what could be considered under freedom of expression, and it is controlling the fundamental right to freedom of expression in a way that probably will not hold in court as a reasonable restriction, which constitutionally is allowed. But these sections, for example, section 33, do they fall under reasonable restrictions? And as we've been discussing even within the coalition, they do not. They smack of extreme control and extreme intrusion, particularly of intermediaries. And as Bishakha has talked about the whole area of pornography and what could come under it in these very, very large definitions or lack of definition rather, and other speakers before me have brought up the point about vague definition. And vague definitions are in a way they arm law enforcement agencies far beyond the reach of maybe the letter and spirit of the law. And the same thing applies in the sections related to intermediary liability, where any intermediary, any digital platform can be held liable for any content on it. And this is something that all digital platforms have been fighting against in terms of who does the gatekeeping, who controls, and who has a stake in keeping who out. This is again an evolving field because the digital space is yet, still to be understood in many spheres, particularly in the legal sphere. So there is an IT Act, as probably everybody knows, IT Act of 2000, which does provide what's called a safe harbor to intermediaries. But recent laws, which were passed in 2021, earlier this year, the IT rules, which is the Intermediary Guidelines and Digital Media Ethics Code rules, have also been challenged in court by many news media organizations for being a complete overreach in terms of control, because it's just not possible to monitor content on intermediary platforms, and nor is it desirable. In no democracy in the world would this kind of control pass as necessary to stop any crime, leave aside the crime of trafficking. So it's complete overreach and criminalizing of any kinds of free speech. And this would be then, it has an implication in other ways also. It has implications in terms of a larger legal landscape, which is sought to be enacted. So I'll just mention it's not just the trafficking bill which is creating this landscape of control and criminalization. It is also the IT rules which were passed with almost no debate in Parliament, the DNA bill, which again has serious implications for privacy and data protection, and consent of the parties whose DNA is being accessed and stored. And in the absence of a data privacy law and regime, these kind of laws which allow surveillance, regulation, control, and so-called access to your data, which is in the interest of a crime. These are extremely problematic, and we see this as a serious clampdown and squeezing of the space for any kind of free expression, leave aside dissent, or leave aside any kind of anti-government or anti-state content. So we also see this as an attempt to control what has emerged as one of the most vibrant spaces in the past few years. We have all seen over the past at least 6 to 7 years that even the media, the criticality of the media has been dampened through various kinds of tactics, such as direct censorship, to cases foisted of defamation, sedition, law enforcement directorate raids, and so on. We have a certain section of the media which is very compliant and very willing to take a pro-government stand on any issue. and an emerging digital news media space, which has defied a lot of these strictures and has defied a lot of unwritten laws of censorship. And it is this space again which is being clamped down upon, and this needs to be viewed with a lot more seriousness than I think the media is viewing this so far. There are other points I'd like to cover, but we can leave them for the next round. Thank you so much.
Immense thanks, Lakshmi. It's been a wonderful presentations. By the presentation that I have seen now from the panelists, it clearly demonstrates one simple fact, that this law is certainly not well thought, well planned law. A law which does not take the interest of the stakeholders, take the interest of that particular segment, of vulnerable sections of society. Their interest is not taken care. It looks and appears from the construct the kind of bureaucratic control which extends without there being a proper consent being taken from the communities which are going to be affected in respect of their rights or consent. This is something which is very, very clear from all the presentations. In the light of this situation, there are a number of questions that arise. In fact, this law, when we were discussing earlier, we said that once you look into the kind of law that we have on hand in the trafficking bill, it throws open millions of questions. There's so many issues, so many questions from the vulnerable communities, because it's large, all-encompassing law which is trying to create a situation where the state gets that amount of control, that amount of situation where the persons who are going to be victims are going to be treated less than human. It's almost to the degree that they're going to be treated less than human. That's what the challenge from the kind of clarification, the kind of questions that have been raised by the panelists today. In light of this particular thing, there are a set of questions that have been prepared. I would like to ask each panelist a question before we still further throw it open for others to make a presentation. The first question would be to Aarti. It's for you. The question is that what are the recommendations of the coalition for an inclusive approach towards the trafficking bill? In fact, there is a coalition of all the organizations that have been working towards explaining this particular law, how difficult it is going to be, how difficult it is going to be, and a need for this particular law to be looked into from a perspective from the communities, perspective from the vulnerable communities, perspective of the communities which are going to be affected by this particular law. I think I'll request Aarti to also make a presentation, short, brief presentation on the coalition and this particular question, recommendations of the coalitions to inclusive approach to the trafficking bill 2021. Aarti, now to you.
Thank you, Preeti. I think just to watch so many viewpoints coming in today is itself a sort of a recognition that trafficking laws and anti-trafficking responses are not just limited to sex work. And that's literally the journey that this coalition has taken way back from when we saw the initial version. And many of you who are not aware, this is literally the 5th or 6th open draft that we have seen in the public space around trafficking laws. Way back in 2015-16, when we started putting this coalition together, the biggest challenge that many of us who are now in this coalition faced is, well, it's got nothing to do with us. It's got nothing to do with worker rights. It's got nothing to do with so on, so segment. This segment does not get included. It's about these people who are victims of trafficking. And who is victims of trafficking? People who are in commercially sexually exploited, right? So 5 years has been a big journey for this coalition, and as it's kept rolling, it's gathered more and more people. So today, the fact that we are getting labor groups to join into the thing, people who are in the digital space, who are looking at freedom of expression, who are looking at internet and the way that spaces are closing, who are looking at multiple areas, are now coming forward to be members of an active alliance. I think that's really a huge critical movement forward, that anti-trafficking laws impact and affect literally everybody. And the fact that we are getting this coalition together is very indicative. Today, there are roughly about 30 active organizations from various segments. The National Network of Sex Workers itself has a huge coalition of roughly 60 collectives in sex work, and about 10 NGOs which are supporting the voices of transgender people, sex workers, the lesbian, gay, bisexual, LGBTQI movement. Now we are getting more and more people joining into this. So the submissions that I had presented, I rode on the shoulders of some very, very respected lawyers, civil society activists. I need to acknowledge that. Coming to the question of what were the recommendations, I think simply put, the biggest recommendation that we have is take NIA off the table. Really, if you want to do good and not harm the anti-trafficking effort, we need to recognize that bringing NIA onto the table is actually going to do tremendous harm. So identifying NIA as the coordinating agency responsible for prevention, investigation, prosecution needs to be removed from the table, regardless of what is being told, because you're actually removing powers from the state, you're removing powers from the district, and vesting it all in a central structure. Secondly, remove adult consenting sex workers and their clients explicitly from the ambit of any formulation regarding anti-trafficking. And the notion of adult consenting sex workers and their clients was a gift given to us by the Honorable Justice Verma in his Verma Commission report in 2013. So he did articulate that there is something called trafficking in women and girls, and there's something called adult consenting sex work and their clients. So remove them explicitly in your objectives and purposes when you're drafting a bill. That really removes a huge amount of harm that you're going to be causing. Third, adopt a very rights-based approach to trafficking when you start upholding the rights of not just affected persons, but moving outside a criminalized response into a development response. So when you're talking about development response, like for example, the Bonded Labor Act provisions, I mean, it is a legislation that looks at the person who is affected by bonded labor, and also looks at how to ensure restitution, keeping the dignity of the individual intact, which requires a lot more money, it requires a lot more resources, it requires a tremendous amount of will to be able to move into a development approach. Sometimes the criminalized approach is easy, but it's not a long-term solution. We need much more wider consultations with stakeholders. All stakeholders who are impacted need to be at the designing table when you're designing such legislation. Let us review existing laws on trafficking, bonded labor, sexual assault, data privacy, media regulation. We've been hearing it from all the panelists. If you need a cohesive approach to anti-trafficking, trafficking legislation, we need to have all these things working in synergy with each other and trying to do minimal harm. You're not out to do maximum harm, and then you say, okay, anybody I gather into that, it's worthwhile. That's really not the approach to go. So minimal harm, maximum consultation, remove sex workers and their clients from the ambit of such legislations, and drop NIA. Thank you so much.
Immense thanks, Arti. It has been joined. That makes the thing much more clear what exactly in store in the law, one part, and second part is what exactly need to go out of this particular law. Now we have Aisha Rai. I request Aisha to come now. सेक्स वर्कर्स के लिए एक कानून ट्रैफिकिंग बिल जो है क्या मायना रखता है, इसके बारे में आप कुछ बताएंगे?
तो जैसे कि पहले भी बताए और ये इस बार भी फिर से बताना चाहूंगी, दोहराना चाहती हूँ कि ट्रैफिकिंग जो है, हमेशा हम सेक्स वर्कर्स ये मानते हैं कि ये एक क्राइम है और इस क्राइम को नहीं होना चाहिए, और सेक्स वर्कर्स लोग खुद एनएसडब्ल्यू लोग खुद काम करती हैं इसके ट्रैफिकिंग के विरोध में, क्योंकि पहले ही मैंने ये बात रखी थी कि सेक्स वर्कर्स जो है एडल्ट कंसेंटिंग, हम वॉलंटरी रहते हैं सेक्स वर्क में, और जो कि ट्रैफिक होके आए या माइनर्स होके आए, उसके लिए हमारे अपने अपने स्टेट्स के लेवल में, जैसे कि उदाहरण में अगर मैं महाराष्ट्र की बात करूं तो वहाँ पे स्मॉल एक कमिटीज बैठाई है, जैसे कि टट्टा मुक्ति समिति बोलते हैं या कुछ रेडिस कमिटी बोलते हैं, कि अपने इलाके में कोई नई लड़की जब आती है तो सबसे पहले हमें मालूम चलता है, क्योंकि हम वहां पर रहते हैं, वो इलाका हमारा है और मैं उस खुद इलाके में रहती हूँ, तो मुझे मालूम होगा कि किस इलाके में नई लड़की आई है। फिर हम उसको पूछताछ करते हैं कि बाबा तुम कहाँ से आई हो, कहाँ नहीं आई हो, तुम्हारे डॉक्यूमेंट्स अप टू डेट है कि नहीं, तुम्हारे चेहरे से भी क्या लगता है, बिकॉज क्या होता है कभी कभी 18-19 साल की लड़की भी 16-17 साल की उम्र की लड़की भी मोटी छोटी रहती तो समझ में नहीं आती, लेकिन डॉक्यूमेंट्स देखने के बाद में उसकी सारी एक्सपीरियंस बहुत जगह से जाके आते हैं हमारे सेक्स वर्कर्स लोग, तो एक्सपीरियंस के बेस पे, और अगर माइनस रहती है तो हमने खुद घर तक उसको भेजा है, क्योंकि हम ये सोचते हैं कि रिस्टोर भी होना चाहिए। हम अगर उसको पुलिस को पकड़ाएंगे और पुलिस की तरफ में भेज के और वो रेस्क्यू होम भेजेगा, ये हम नहीं चाहते। हम सेक्स वर्कर्स ये चाहते हैं कि पुलिस को भी हाथ में लेते हैं, क्योंकि उदाहरण में जब मैं खुद काम की हूँ तो हमने पुलिस को भी हाथ में लिया है इस काम के अंडर में। वो कोऑर्डिनेशन करता है, उस इलाके से पुलिस ऑफिसर को भी आता है और उसको रिस्टोर करते हैं, क्योंकि हम ये सोचते हैं कि माइनर्स का जो है अभी मानसिकता उतनी बड़ी नहीं है, उनकी कंसेंट नहीं है, तो धंधे पे नहीं होनी चाहिए, सेक्स वर्क पे नहीं होनी चाहिए, और हमेशा हम ये बात रखते आए हुए हैं। इसीलिए हम यही बोलते आ रहे हैं कि ट्रैफिकिंग का विषय में सेक्स वर्कर्स लोगों ने बहुत काम किया है, लेकिन सेक्स वर्क और ट्रैफिकिंग को अलग सोच के आप लोग काम कीजिए, ये हमारी सोच हम बोलना चाहेंगे। और ट्रैफिकिंग सेक्स वर्क बिल्कुल ही सेम नहीं है, बहुत अंतर है इसमें। जबरदस्ती फोर्स होता ही नहीं है हमारे सेक्स वर्क में। कंसेंट जो है भाषा, हम बार बार बोलते आ रहे हैं, एडल्ट कंसेंट जो भाषा है वो बार बार हमारे सेक्स वर्क के धंधे में होती है, तो हम ये बोल ही नहीं सकते, और ना हम ये मान्यता करेंगे कभी भी कि ट्रैफिकिंग ही सेक्स वर्क है, इस तरह से हम बिल्कुल मान्यता नहीं करेंगे। तो जिस तरह से मैंने बताया कि हमारी जो छोटी छोटी समिति है उसमें काम करते हैं, जो नई विन्न लड़की है या फिर कोई जबरदस्ती फोर्स से आई हुई है, इस तरह का भी काम हमने बहुत सारा किया है। हमारी एक्सपीरियंस है उसको किस तरह से हैंडल करना, उनसे बात करना, उनको काउंसलिंग करना, अलग प्रकार से साइड में लेके जाके, ताकि उसको किसी का प्रेशर नहीं रहो। ऐसे बहुत सारी केसेस हम लोगों ने, इसीलिए ये सारा जो कमेटी है, स्पेशली हमने ब्रोथल ऑनर्स वगैरह भी इसके अंदर में हमने रखा हुआ है, अपनी घरवालियों के साथ में, अपने यंग सेक्स वर्कर्स के साथ में, ताकि इनको ज्यादा इंफॉर्मेशन रहता है, क्योंकि हमेशा इनके घर पे आते हैं नवीन लड़की या फिर गली में कोई नया आया है, तो इनको ज्यादा रहता है, क्योंकि यंग सेक्स लोग ज्यादा एक्टिव रहते हैं सेक्स वर्क में, तो नया चेहरा दिख रहा है गली में तो इनको मालूम रहता है। तो ज्यादातर हमारी कमेटी इस तरह से बनाई गई है और ट्रैफिकिंग को स्पेशली हम काम करते हैं। और एक चीज यही बताना चाहूंगी कि हमेशा यही बोला जाता है कि सेक्स वर्कर्स जो है ट्रैफिकिंग के विरोध है, लेकिन ट्रैफिकिंग के हम विरोध है, हम मान्यता करते हैं, हम ट्रैफिकिंग को नहीं मानते हमारा सेक्स वर्क, लेकिन ट्रैफिकिंग के लिए हम खुद भी काम करते हैं। हमारी बहुत सारी रिसर्च है। हमारी एक डॉटर ऑफ हिल्स है जो कि खुद हमने कोपिशा का स्टोरी जो है वहां पे हमने खुद नेपाल की एक लड़की थी उसको फिर से अपने एक देश से दूसरी जगह रिस्टोर किया गया। तो इस प्रकार का हमारा बहुत सारा एक्सपीरियंस हम बताना चाहते थे। थैंक यू।
Immense thanks, Aisha. It has been a pleasure listening to you. And that sounds good. Now I request Pompey to come back. Hello, Pompey.
Yes.
There have been questions, but what we had requested, there have been the number of people asking you this particular question. The construct of consent, the absence of consent, consent becoming immaterial under this particular law. And not only me, there was one simply phrased question that we received from the audience, which said, in the absence of consent, can a shelter be called shelter? It's more a prison. So now it's up to you to answer that. And that's one of the major concerns which has been presented, that while the law is relating to help the victim, but if you take the consent away from the victim, the very construct of consent, the choice is taken away from the victim. So that you are going to be housing them without their consent into a shelter. Can you call that a shelter? Or should we call that a prison? And without having committed a crime, someone who has suffered some harm is being imprisoned and literally no rights have been recognized. And this is one of the major questions that we have seen a number of persons raising this issue to you. Please explain.
Thank you so much. I think this is one of the key questions, definitely, especially in the context where in the last decade or so, we have seen how shelter home-based rehabilitation have not worked to the extent in all the contexts where survivors have reported on their experiences of shelter homes. They have always talked about how staying in shelter homes for years on end has not empowered them. Now, coming to the specific question of how consent is viewed in this TIP bill, let us first look at which are the clauses where consent is mentioned. Of course, there is clause 23, that is defining trafficking in person, and the explanation 2, which states the consent of the victim shall be irrelevant and immaterial in determination of the offense of trafficking in persons if any of the means mentioned at B is used to commit the crime. The other clauses where consent is referred to is clause 19, subclause 4 and subclause 5. Also, clause 16, subclause 7 and subclause 11. Taking a look at this, to answer in a very crisp manner, can any adult person ever be put in a shelter home without their consent? No, they cannot. If they are put in any facility without their consent, it is forced detention. Now, when it comes to the definition of trafficking, this part where it mentions which are the means that is to be determined, this is where I believe the process of the victim's 164 statement before the magistrate will be very, very important. And before I go into that, let me establish that under the legal framework of India, no person below the age of 18 is capable of giving consent. So when we are talking about consent, we are talking about consent of an adult person. Now, in front of the magistrate, a person is not asked whether you were in this situation with your consent or not. There are certain very fixed questions that the magistrate is supposed to ask to the victim. Your name, and can you see anyone else here? Followed by, tell me what has happened. Now, in that narrative, if the victim states any of these means or of threat, use of force, coercion, abduction, fraud, deception, or power was abused, a position of authority or vulnerability was abused by a person, or there was any giving or receiving of payment or benefits to achieve the consent of a person. For example, in labor trafficking, one of the ways the middle person gains consent of the person, quote unquote consent, is by giving of a lump sum amount of money as advance to make the victim fall into a debt trap, which is then exploited to force that person into the situation of trafficking and labor exploitation. Now, in that 164 statement, if any of these means are present, therefore, in that context, the victim cannot have consented to being coerced or abducted. It is understood. When it comes to shelter home and keeping an adult person in a shelter home, Section 19 and subsection 4, my apologies, clause 19 subclause 4 states that a victim under this act shall not be held any detention facility merely on the basis of their status as victims, which means that any adult person, just because they are a victim of trafficking, cannot be kept in any shelter home, be it protection or rehabilitation home, if they are not willing to stay there. Further, this clause 19 subclause 5 states all assistance services shall be provided on a consensual and informed basis, and while taking due account of the special or specific needs of victims, especially if they are women, children, or disabled persons. And this is where I believe we must look further to strengthen the fact that no person can ever be given any service or forced to remain in a shelter home without informed choice. A person's choice to stay in a shelter home must be an informed choice. And it is interesting to note that this clause 19 subclause 5 even mentions children. So it mandates that whoever are the authorities, they must ensure even a child takes an informed decision. Further, if we look at section 6, clause 16, subclause 7, this creates one doorway through which a person can exit voluntarily out of a rehabilitation home. Now, in here, the paragraph number 2 actually says, if the magistrate is of the opinion that the application has not been made voluntarily or was not a consensual act by the victim, the magistrate can reject such application, which is curious, because if it is an adult person we are talking about, why should this person have to make an application to step out of a shelter home or for the purpose which is purported to support them? And clause 16 subclause 11 further strengthens this, this method of application for exit. It makes it important for the magistrate to make an inquiry to let even an adult person out of the shelter home. It actually explicitly mentions that capacity of genuineness of the parents, guardian, or spouse to keep such person has to be first ascertained before they are handed over. the handing over has to be done by passing an order by the magistrate. This is where this bill, I believe, goes against the consent of an adult person. The choice to leave any home, shelter home, for either short-term protection or longer-term rehabilitation should be available to an adult person, and they should not have to make an application and go through this entire process. This is how I would like to respond to the question around consent.
Thank you, Pawan. Thank you very much. Now I request Bishaka. Hello, Bishaka. Bishaka?
Yes, should I?
Hi, Bishaka. There is some tag. See, there is very interesting. When we talk in terms of consent, as Pompey was talking in terms of, it again raises a question to you too, that it talks consent in many places. This yardstick of consent, how it is being presented, the construct that the consent, it becomes material in some places. Many of these constructs you're talking in terms of, or the victim and the shelter construct, which was presented by Pompey relating to rehabilitation and rescue, the short term, the kind of construct we talk in terms of where the victim is put in a system where the choice which the victim has is not available. Now the construct which is being asked also in respect is that whether this construct of or the yardstick of consent is relatable to the pornography, in relation to pornography. How are we to look at this particular construct is something which is a question. Yeah.
Thanks very much, Venkatesh. Yeah, let me try and answer that. So, again, let's start with what Aisha talked about and what Aarti talked about, right? Adult consent. Pompey talked about the age of consent being over 18 years, right? And we know that the age of consent is defined as for sexual consent, right? That's what it really applies to. So what I would like to say is that I think we have to apply exactly the same yardstick to consent related to sex, whether it is in physical space or whether it is in digital space. And when we talk about the pornography or digital spaces, we are essentially talking about the production of sexual material online, right? Adult sex workers usually share images and videos that they have consensually produced with their clients. But here's where I want to show why it's really a problem to actually, erase or dismiss or ignore consent, adult consent. So again, in the example I gave earlier, say a sex worker sends a video to a client by whatever, WhatsApp or whatever. And let's say that the understanding or the transaction is that this is for his use and his use alone. And let's say he then circulates that video to some of his friends. That is a violation of consent, right? In the first instance, she has produced that video consensually and shared it with him. But when he shares it further with others, that is a violation of consent. And that is actually harm for her, right? But the problem is that when we define sort of all of pornography or all of something as somehow non-consensual, we are not able to address that particular harm, even though under the Information Technology Act, there is a section called Section 66E, which deals specifically with the non-consensual circulation of images. And it basically says that, whoever intentionally or knowingly captures, publishes, or transmits the image of a private area of any person without his or her consent, under circumstances violating the privacy of that person, shall be punished with imprisonment and a fine, etc. So what I'm trying to say is that, on the one hand, the Information Technology Act recognizes the difference between the consensual production of intimate images, material, etc., and its non-consensual production or distribution, right? And so it's very, very important, if we look at this through the eyes, through the lives, through the experience and the lenses of sex workers themselves, that we recognize the fault line of consent, right? And we need to recognize it at each stage. For example, one of the phenomenon that we see in the digital age, and really an awful sort of phenomenon, is the linking of videos with sexual assault and rape. Now we know, for example, that sex workers, like others, can be sexually assaulted or raped, and that it's been very difficult for them to actually get redress in the justice system, etc. What we are seeing now is that act of rape is being turned into what's called a rape video or pornographic material, right? Now, obviously, that is being turned into a video without the consent of the sex worker. So you see, you're seeing now in this kind of situation where the consent of the sex worker is taken away during an act of rape, then during its filming or turning it into porn, into sort of like harmful porn, and then circulating it further. So there are actually 3 counts of consent violations, right? And it's very, very important for policies, programs, etc., to recognize this yardstick of consent, both in digital spaces as well as in physical. I'll end here. Thank you.
Thank you, Vishaka. In fact, this is really the explanatory part. There is one question which is additional value. One of the major aspects in India is that the construct of obscenity, the idea of taboo, the kind of the moralistic approach. For example, now I'm a practicing lawyer. So a good number of us will say this individual prejudices that the system has, whether it is the investigating officer, whether it is the judge, whether it is the counsel who is conducting the cases, many times we have come across these personal prejudices, the moralistic approach on many of these aspects. We look into it. So when you look from that construct, the law relating to obscenity which we have is so vaguely worded. In fact, the terminology which you employ relating to the construct of consent, relating to, and you also the way you present 3 aspects, like what is sexual, what's erotic, what exactly is the hormonal pornography. Well, you have made it very clear presentation, but when it comes down to the law that we have in existence, when it relating to obscenity is concerned, under the Indian Penal Code, many of these things would go towards one part, that any of this concept, an issue which goes into public space would be an offense, would be somebody who is participating in it would be an offense. So because anything that gets circulated would be an offense, because that's the thing which is there of the day, becomes a publication, and therefore it becomes a person, anyone involved in that kind of production of that particular thing, anyone participating in that particular video would become an accused under the Indian Penal Code per se. So actually that is all the definition part which is already existing is concerned. So what exactly, how exactly you view when we saw vis-a-vis in respect to this trafficking bill and that particular aspect of the Indian Penal Code is concerned? And also, I would like you to explain a little bit relating to the taboo and the personal prejudices and moralistic approach that we have in the system, how it actually defines our approach towards trafficking. Please.
Thank you.
Maybe I made it a little long, but this I think you
no,
got
no,
what I.
This is great, Venkatesh. You have asked me something that is one of my passions, actually, because we did a study looking at the Information Technology Act's 2 provisions. One is the law around the provision on digital obscenity, section 67, and the one that I just talked about, which is non-consensual images. And what we found was that, even when the harm was very clearly, the crime was very clearly a violation of consent or privacy, it was always being booked under Section 67 or under the section that that labeled that image as obscene. So a private harm, in a sense, was being converted into a public harm. The private harm or the individual harm was not being recognized, but rather the public harm, and harm in quotes. So I think, just to again answer your question, I think the issue is that we are a society that is actually deeply uncomfortable about sex and sexuality. We don't talk about it, it is stigmatized, it is taboo, etc. We have a very moralistic view towards sex and sexuality, and we feel that the only legitimate reason for sex is actually reproduction, to have children, right? So as a society, we don't recognize other forms of sexuality or sex, including, same-sex relationships, relationships outside marriage, transactional sex, the paid exchange of sexual services. And I think because of this deep discomfort with sexuality, we tend to take all material that is produced for sexual purposes and immediately think of it as like dirty or deviant or obscene or illegitimate, basically, right? Instead of saying that, okay, it is legitimate unless that there's nothing wrong with sex. There's nothing wrong with producing adult sexual material, right? And that it's legitimate as long as it is consensual, as long as it is not harmful. But the whole of it is dubbed obscene. So that's what I wanted to say. Thank you.
Lakshmi?
Yeah.
Lakshmi, there's one question which we are discussing. This has been really very interesting discussion, which is going, would you please come on video, please?
Yes, I am on video.
Yeah. The question is that how does the provision of mandatory reporting impact press freedom and the research of inquiry? This is one aspect which has been asked by many. In fact, the question of freedom of expression vis-a-vis the construct of mandatory reporting. Now, one set of questions which comes into is that one of the major challenges that we have in trafficking is that the agency is unable to get the information relating to the happening of a trafficking situation. Now, there is a need that we get to know the information so as to help us to rescue and protect these people. That's the whole concept which the law talks in terms of. Now, how exactly would that impact the freedom of expression? What exactly is this construct of why there is an opposition to mandatory reporting? What exactly issues regarding the same? I think that's one of the challenging questions that has been asked.
Yeah. Okay, thanks, Venkatesh. Actually, this is an issue not only in this act. Even earlier in the POXCO Act, there have been concerns from health professionals and counselors and those working with abused children or survivors of child sexual abuse. Because somewhere the whole police process, and we all know, we don't need to tell this audience about the problems with the law enforcement process, which is not particularly sensitive to children or any even adult survivors of violence of any kind. So to bring in that whole law enforcement process without adequate provision for counseling or healing or any kind of intervention in addressing trauma is the problem. It's been a problem even with POXCO. It also is a question of consent. Does the survivor want to pursue a police complaint, and the law enforcement system being what it is? Many women choose not to, actually. And mandatory police reporting takes away their agency in whether or not they want to pursue a criminal prosecution. That is one point. The other is that this particular section, which is section 35(1), which provides for mandatory police reporting, must also be seen in this larger context of control and criminalization. So not only are you criminalizing those involved with trafficking, you're in a way penalizing even the victims by all the processes which were described before about, forcible rehab and what could actually be termed detainment. So not only that, you are criminalizing a whole ecosystem of the public. And it's not only people involved with sex work here, it is a larger ecosystem. So a whole bunch of places have been identified. For example, any dwelling, any hotel, a whole bunch of people have been, made liable. So what it says is every person who knows or has reason to believe that an act of trafficking has taken place, that a person has been trafficked or that an offense under this act has been committed shall report it, it says, forthwith to the nearest police station. So it's not just what you know as in evidence-based. It is a very slippery slope here because it says who has reason to believe. In the recent past, we've seen the way in which this reason to believe or a suspicion has led to vigilantism of a very, very severe scale, leading to violence. So-called child traffickers who've been suspected of child trafficking have been lynched, have been beaten up, have been brutally harassed, whole families of people, just on the mere suspicion. And it is again no coincidence that many of these belong to minority religions. So it increases vulnerability on a very large scale, and many kind of biases, as you yourself have just brought up, many biases, prejudices, and plain hate come together in provisions like this. So for example, Islamophobia can very well be beautifully knitted into this provision of mandatory police reporting, if you even have a reason to believe. And coupled with another very dangerous provision of this act, which is a lack of a presumption of offense. And the whole burden of proof then is placed on the defense, not on the prosecution, like in any other crime, where a person is presumed innocent until proven guilty. This has been turned on its head, where it is a presumption of offense and not a presumption of innocence. So going alongside a presumption of offense, this broad sort of provision which says every person who knows, who has reason to believe, shall report. So not only are you creating a condition where you have to report, it is creating a condition where you yourself are liable if you do not report. So how it has implications for the media is this, that any investigative story, for example, which breaks in the media, is the work of months, sometimes years of work. It is not a one scoop which is given by a handout in a police station. Like a lot of stories by the crime beat, basically it's reproduction of a police handout. That is not the case in genuine investigative stories. So the point being that if it is a presumption of offense along with mandatory reporting, you are going to be putting a whole bunch of people into your net, a whole bunch of people who are criminalized. So media people pursuing a story. You might have reason to believe that X or Y woman or child has been trafficked. You might have reason to believe certain people are traffickers. But in the pursuit of your story, you have to keep this information to yourself, unless, of course, anybody's life is endangered. That is, again, a separate call of ethics which a journalist has to make. But just knowing someone or a presumption, it is killing any kind of investigation into this crime. Same with research. If you are researching trafficked persons, and the only way you will not be liable is if you speak only to people in a so-called rescue home or whatever. I mean, anyone who's not outside these spaces, will put you liable to prosecution for the crime with imprisonment and a fine and so on and so forth. The other point is, as has been brought up before, the very vague non-definition in a way of exploitation. So if you have reason to believe somebody is being exploited, this is, I mean, it could be just anything and everything. And one shudders to think where this kind of vigilantism is going to end, because it does not provide for any checks and balances. It does not provide for any screening of the kind of identification of a crime, because you are not just empowering the general public with powers to report, but you are criminalizing them if they do not report. And such kinds of trends are extremely dangerous in terms of how law enforcement itself is viewed. You are in a way letting the police ride on the back of journalists to do investigations and penalize them if they do not report it to the police. So I see a very, very dangerous trend being established by law. And, one is going to put in all effort to ensure that this is not enacted as, does not come into the legal statutes. Thank you.
Immense thanks, Lakshmi. It makes great sense. One aspect which goes most in this webinar, in fact, we're coming to the concluding part of the same, is that the discussions that have gone through, I think by the time you have heard various aspects of the law of trafficking, how it has been impactful. Let me give you some very interesting examples of the existing laws that we have and the way things are being done. One of the major challenges that we have in this country is the way policing is done. We have a great challenge in policing, great challenge in the sense that the kind of investigative techniques that are employed in this country are ancient. In fact, so ancient that it really surprising that we are running such institution even as in the 21st century is concerned. That demonstrates one part. Second part is that the interference in the police departments in their investigation. There are a number of very amazing skilled investigating officers, as I have seen as a prosecutor and as a defense counsel, the kind of work that they have done. But however, what happens is that the interference in the investigative processes by the administration or the politics has caused great amount of harm in policing is concerned. This under serious concern. It's not just, there have been a number of reports in respect to the same in police commissions that have happened, and also the reports on police reforms that have taken presented. Now, there is also one serious question relating to the impunity is concerned. One of the challenges where that in India, the failure to investigate a proper case and the victim being not compensated in respect of a acquittal in a case where it has been falsely implicated causes such kind of challenge in this country that the impunity of the state goes unpunished. This is one of the major challenges. And there are many shortcomings in the processes that we have in existing system, whether it's the investigation under the Criminal Procedure Code or whether investigations which are being conducted in various special laws are concerned. Now, when we look into these constructs, we had seen that the state came up with making the law more and more stringent, arming the police more to the teeth in respect to the same. In the process of arming the police, what has happened is that the kind of laws that we have, in fact, just 3 days ago, we had the judges of the Supreme Court, retired judges of the Supreme Court, making it very clear that Unlawful Activities Prevention Act is a draconian law. It has to go. They said that the National Investigating Agency Act smacks on freedom of expression, smacks on the constitutional guarantees which are guaranteed to every citizen, every person in this particular country who is residing, not necessarily even the citizen. Now, such is the power of the constitutional freedoms which has been guaranteed. And even the construct, as Lakshmi Murthy was referring to regarding the adversarial construct of criminal jurisprudence, that is, a person is to be treated innocent until proven guilty beyond reasonable doubt before a court of law for an offense which is punishable as on the day of commission of that particular crime is concerned. That should be declared. There is such amount of clarity being there in the Constitution. That's being undone from the construct of the presumptive value and also the construct of the way the investigations are being done. And for example, when you look into the National Investigating Agency Act provisions, that the non-disclosure name of the witness to the accused is permissible. In fact, many of these issues which are actually in a way taking away the right of an accused for a fair trial are being included in this particular process. Now, the challenge, as was stated by Artipai, was that such law is being introduced in respect of trafficking is concerned. One of the major challenges that the coalition and the experts had expressed today, and many outside who have been working on these issues have been talking, are in respect of vulnerable communities being made more vulnerable. In fact, very construct, when you talk in terms of, as Arti and as Aisha were talking in terms, or Poppy were talking in terms of, Bishaka was talking in terms of, was relating to the choice, sex work as a choice. One of the aspects of the trafficking is relatable to sex work as a choice. A person, for her own employment, she chooses to be a sex worker. The construct of a victim in need of a shelter, construct of a worker who is a victim who is in need of a rescue, demonstrates somewhere in the process that we are unwilling to accept that she is a worker delivering a set of services which are accepted. Now, what exactly has happened in this country and in the law which we have is that we have not defined in all places what exactly that the sex work is an offense. We have not said that prostitution or sex work is an offense. What exactly is an offense is every attendant circumstance to it and existing ITPA. A great number of people are challenging this particular law for the reason that it is the vulnerable community of sex workers, deprived community of sex workers who are being targeted in this country. In fact, that is precisely the reason why I raised a question with Bishaka relating to the taboos, relating to the personal prejudices, related to the moralist approach that we have in the system, which impacts that every sex worker is considered to be a trafficked person, not necessarily a worker. So thereby taking away her right to negotiate, taking away her right to organize, taking away her right for all the rights of a worker which she is entitled to. This trafficking bill, in the absence of not answering such kind of situation, which is being a long-term demand of the sex workers, makes it more draconian with the constructs and presumptions that are being brought into the law. In fact, the community becomes more vulnerable. Ayesha made it very clear that the constructs of this nature which drive the community underground and make it more difficult for them to negotiate, risking their health issues, risking their livelihood issues, and risking their safety issues. Many of these things go unanswered. In fact, coming from that construct also is the consent. In fact, Pompey's questions were very, very clear and loud relating to the challenge which it faces. While we talk in terms of, when once we say that there is consent is immaterial in respect of a victim is concerned, is the person a victim being rescued, or a person is being pushed, ushered into a rescue or shelter home for a longer period? Is it not a choice? What is the difference between a shelter and a prison? A prison is a place where there is no choice of the person to come out of it. He has to make an application to come out of it. A shelter, if it all is a place a person can voluntarily seek it or voluntarily say that I don't require it anymore. Now that making that statement, I don't require it anymore, should it be a process wherein he has to go to the magistrate, make an application, magistrate evaluate the same, whether he's entitled to make such a choice, and that takes away the right of the person. The person is no more a victim, but more particularly he is driven to the construct of a prisoner, the shelter being termed as a prison. In fact, it opened millions and millions of questions. The whole construct of law that we have, accepted constitutional guarantees that we have, are being undone by such laws. It's not just one trafficking bill 2021 that we are looking at. In fact, very clearly, Lakshmi Murthy was stating that the host of legislations that are in existence, which are likely to come into existence, which take away these constitutional guarantees, that becomes much more worrisome in the times that we are living in. In fact, the way we look into the law, in fact, the Lakshmi Murthy's statement at the end of the course regarding the reason to suspect, the construct of reason to suspect, and the consequences of the same. And then there is a very interesting book that we have on this subject by Amitabh Kumar's Evidence of Suspicion. As an advocate who have conducted a number of similar cases that we have, that the evidence of suspicion is sufficient for a person to be prosecuted, and great number of cases, persons have been subjected to longer incarceration for years and years on end in this country. And we have greater examples, even as on this day, great number of tribals being prosecuted, great number of vulnerable communities being prosecuted. Also that we have these reports which have been done, studies being done in this country. For example, for your information, that we have close to 60 to 70,000 prisoners in Indian prisons, which is 117% of the capacity of the prisons. The more than the prisons can hold, we have the prisoners in our prisons. That apart, when you look into the persons who are in prison, 70% of them are under trial prisoners awaiting the trial. They are not presumed guilty. They are innocent, and their guilt is yet to be proved. They are in prison, and they constitute 70% in Indian prisons. How come that we have serious questions not being raised on this issue? So when you look from that construct, what exactly are these laws going to do? Are we increasing prisons? Are we making it much more difficult for the victims? What exactly happens to the communities that are dependent? What exactly happens to the families of these particular victims? So when we look at this law, there have been serious challenges. In fact, my own personal experience as a state public prosecutor, there was an instance relating to a rescue shelter. The High Court judge said that I would not like the person to be in state shelter. State shelters are not being properly maintained. We know how badly they are maintained, how badly the people are treated. The construct is that the notions that we have relating to a rescue home and a shelter home are so difficult because they have not been made places which is healthier, safer places for people to live in. That is one of the challenges that we have regarding the same. It's a systemic issue. In the absence of addressing the systemic issue, arming the system to the teeth, is it going to answer the challenges that we have? Or is it going to make communities which are already vulnerable more vulnerable? I think these are million questions that are being raised by the communities as against the authorities are concerned. Most important, apart from all these things, is that what Arti stated in the beginning of her presentation and also during the questions, that there is a need for a broader discussion, debate on the subject before any law being made. The communities which are affected need to be inquired into. Their views need to be considered. It's not just bureaucratic exercise of bringing a particular legislation. In fact, if we were to look into the construct, that the bureaucratic mechanism in this the statute is being armed to teeth. I think that's something which is a challenge. In fact, Pompey's statement regarding the rehabilitation issues and rescue issues, how that the person's challenges are not being addressed in this particular law, which has been already being asked so many times by the organizations, not being addressed and continue to be much more stringently denied in the new laws that are being presented to us in this new trafficking bill. It opens more questions than addressing the issues. I think that's something that's being challenged, that's being questioned by coalitions, groups, individuals intellectuals, people who love freedom, people who have concern, people who really worried regarding the issue of trafficking, that this is something they think which should not be buried under the carpet, which cannot be pushed under the carpet, as has been. That's what they allegate, that was the questions, that's the concerns that the communities are presenting. I think we would close this webinar in this particular statement. Therefore, we make that particular song in the beginning of Faiz Ahmad Faiz, Kutte, that the vulnerable communities have little, no voice, they have been denied. We just live along. They make their life of insignificance makes them not being concerned or not being worried about or taken into consideration while making any statute, which is being done, supposed to have been done, which is being presented to be done in benefit of these communities. I think with this, we would close this webinar. I sincerely request thank all of them who participated in this particular program, first part. And this could not have happened but for the wonderful support that we had received from the interns who worked with us, Malavika, Darshini Sukumaran, Priyanka Chakraborty, and the person who made it possible, the whole streaming of this particular program and hosting this particular program, Mr. Nitin Baburjan. All of them contributed substantially in collecting questions to us and presenting me the opportunity to ask questions to the panelists. I thank all of them. They have made this program so beautiful. And most important is that the kind of discussion that we had today demonstrates the quality of expertise of each panelist. Each come from the decades of experience, decades of expertise that have acquired over a period of time on the aspects which they were talking about. Lakshmi Murthy is a senior journalist who has worked across South Asia on these issues of rights of the people are concerned. And she is co-founder of Free Speech Collective, an organization wedded to the cause of free speech and trying to present all the information to the public relating to the challenges that we have and the challenges that need to be addressed. And we have Bishaka Datta, in that you heard her, who has given such amount of quality films on this, write-up on this particular aspect, and such amount of research on the subject is concerned, who had an opportunity, who had been reading her for more than 2 decades. And she is here today, she was here today, presenting in that kind of beautiful, nuanced presentation relating to the rights of issues, challenge that we have, whether it is taboo, or whether it is personal prejudice, whether it is the kind of moralistic approach that we have, whether it is the rights of a sex worker and the constructs of sexuality, the construct of eroticism, and the construct of harmful pornography. What exactly is that? And the digital age, the kind of digital construct, digital spaces, she has an amazing expertise, which she had she explained it to us in much beautiful detail. I immensely benefited from that. I think many of us have benefited from the presentation of the panelists. Lakshmi Murthy and Bishaka Datta have done amazing on that particular. I'm immensely thankful to them on that particular front. And I thank Pompey. Pompey Banerjee has come with such beautiful presentation relatable to rehabilitation and rescue that speaks volumes about the kind of work that she has done on the field in respect of the communities and the kind of concrete suggestions that she brought, not only regarding rehabilitation, but also the construct of accountability into the law relating to trafficking is concerned. What exactly a victim is, how exactly the state need to be accountable for the same. I think that's very speaks volumes about the democratic concerns in a society which the constitution is, supremacy of the constitution is accepted law. What exactly should be the way we have to have accountability? I think she was very, very wonderful, nuanced presentation that we have from Pompey. It was extremely wonderful that we had someone like Pompey to explain it to us. We had Aisha Rai, the sex worker herself. She had worked with the community. She is working with the community. She is the coordinator of National Network of Sex Workers. And she has done volumes of work relating to health issues, livelihood issues, and issues related to the rights and expressions of the community. That makes it a wonderful presentation from the community perspective, which was lacking in the whole programming we were looking at. She brought in that kind of a very, very critical presentation in respect to the rights of consent. I'm immensely thankful to Aisha Rai for being part of this particular webinar and being done. And of course, my fellow lawyer, Arti Pai. We always, end of the day, it's always the fraternity we talk in terms of, she's part of the fraternity. And she brings in the kind of work that has happened. She's the executive director of Sangram Sanstha, and she has done volumes of works on this particular issue and the way law needs to be done. What exactly the process of legislation? What should be the concerns of the legislation? And all these aspects have been in detail, to final details, she has been presented. Well, does it mean that we have covered good part of this particular subject is concerned? I doubt so. The question is that this law which is being presented opens so many more million questions that have not been answered. And this all that we are doing today in this webinar is only to open up and see what exactly the challenges are. In fact, each of the panels that we had today had so much more to speak. The constraints of time, the constraints of the challenge of presentation of the same was something which restricted us to frame it within a span of 2 hours today. So I am extremely thankful to every panelist making this possible. And I'm also extremely thankful for all the persons who had helped us with Meena Shishu, Rajesh Sangama, and Madhubhushan, all of them who have helped us in this process in trying to evolve this whole concept of this particular program. Reach Lawyer is indebted to everyone for making this webinar one of the most successful webinars. I'm very thankful to all of you. And with this, we close today's webinar. Thank you very much.